Let me begin by thanking you all for honoring our invitation to this groundbreaking edition of the National Assembly Business Environment Roundtable. I thank you because I look at the present in this hall today, and it's clear that we begin to build some level of confidence. Because I remember programs like this before we hardly fulfill this room. So I think it's a message that we're beginning to get somewhere. And I think as we continue to forge ahead, the relationship between the private sector and the National Assembly will flourish. I want to thank the technical team that has worked so hard, Professor Paul and the development partners, DFID Enable Project, the Economic Summit Group, Nigeria Bar Association for working so hard to make today a reality. When this present National Assembly came to the saddle last year, we set forth, therefore, to frame a specific legislative agenda to guide our legislative priorities. We realized that, unlike in the past, there was need for us to address the area of priorities and begin to work in that direction. Our agenda was conceived on the notion of a renewed national development imperative, which puts harnessing private sector at the fulcrum for national growth and development. And to achieve this, will require deliberate steps to redefine the Nigerian business and investment climate using lawmaking. It all starts with a comprehensive legislative review. Our dear President Buhari had laid down for us a vision for a diversified economy away from too much dependence on oil, ensure security of our people's life, create employment for our people, expand our economic opportunities, and close the gap on our infrastructure deficit. The National Assembly has in tandem made these the vision and anchor point of our legislative agenda. And for us, this is not just a mere agenda or not a mantra or talk, but it's something that we're going to take a purposeful action towards. We are determined to achieve our goal, and part of that process is what we're seeing this morning. Distinguished colleagues, honorable members, and invited guests, the federal government in the last 14 years has attempted to pursue far-reaching reforms of the economy through deregulation and privatization, but this has not yielded the desired result as affected enterprises continue to underperform, unemployment continues to grow, business continue to fall in record numbers, and private sector continues to grow. Many have opined that the notice failure has been occasioned by the failure of government to work with the legislature to underpin the reform policy with institutional, regulatory, and legal review on which the emerging economy will rest. The Nigerian business environment today is running largely on obsolete laws, weak governance framework, fragmented regulatory structures bogged down by inhibiting practices, with very weak accountability mechanisms. How deep this problem runs was until today very unclear. It is the need to methodically deal with this and create a new architecture for businesses to thrive in Nigeria that necessitated this project. It is for this reason that we have gathered here today. The National Assembly has launched this specific economic and business environment roundtable to further interrogate this report, validate its conclusions, get the buy-in of key stakeholders in our business environment, including the organized private sector, key government agencies, policymakers, regulators, the media, civil society, and other stakeholders. For us as lawmakers, our democracy is deepened and our lawmaking is enriched by great citizen participation, consultation, engagement, and involvement. Today's event, as I said, is a great step forward. This will be the first time, aside public hearing engagement, the National Assembly will be engaging the private sector, public sector robustly in the policy or lawmaking process. We have gone down this route because we believe that if we deliberately involve and continuously engage our people in lawmaking, the edits and policies we will make will be greatly enriched and accepted, have been a product of collective consensus. It has also been shown that 96% of jobs in the developing countries are in the private sector. So if it is our drive to fight unemployment, provide a new Nigeria, we must engage the private sector. It is my belief and my hope that at the end of today's session, the reports that have been put together by the technocrats will have an opportunity for your contribution and your views. What I want to assure you is that for the National Assembly, we have begun this process largely to build confidence in the National Assembly and the legislative arm of government. We are here representing you, and we're here to show you that it is not going to be business as usual in the 8th National Assembly. And we have started our step in going through a methodological approach in creating this report. Secondly, this report was submitted to us on the 29th of February. And I'm happy to say that less than a month after that report, we're here gathered this morning for your own input to make your contribution. At the end of your contribution, the next step for us is to begin to start passing these bills into law. Thirdly, and more importantly, is the presence of the Honorable Speaker, represented by the Chief Whip. The message here across to the private sector is that the National Assembly, House of Rep, and the Senate are working very closely together in this 8th National Assembly. And as such, you have a commitment that some of these processes will not be bogged down and not be passed because one chamber is doing something differently. We're both committed. We've both come out with our agendas. We've both worked to see the agendas are the same. And as part of this commitment, you all see next week when we lay down the Petroleum Industry Governance Bill, you will see that the bill we're going to lay in the House is the same bill we're going to lay in the Senate. Because for the first time, we're focusing and we're working together. For those of you who are here, after you've done the work and given it to us, the work doesn't stop there. You must continue. You have 109 senators, 360 House members. Like in all countries of democracy, you must continue to knock on their door until we pass this bill. I can't do it alone. We on this table cannot do it alone. We can only do it with you making us do the work that we're meant to do. And that is mean until these bills are passed, these summits and this engagement must continue so that it is not just talk. I can assure you on our part, we will provide the leadership. We are committed to do this. We don't know it all, and that's why you're here today, to tell us what works to make the private sector move forward, to make jobs, to also create jobs, and to provide an enabling environment that people come and invest in Nigeria. I think once we share this responsibility, I am confident that as a country will begin to move forward.
It is my pleasure, of course, to be here to interact with business people, investors, indigenous and foreign investors that are readily available to help to turn around Nigeria's economy to a greater height. And I want to thank and commend the initiators of this initiative, because the initiative for me has come at a very right time, very appropriate time. In fact, at a time one could say would not have been better than now, because I want to believe that this is a very critical economic period of this country that requires the contribution and support of investors and business people to help to turn around our economy. I said it's critical because it is at this time when our economy is perfectly at a standstill, and we really need the hands of investors, professionals, within and outside the country to come and help support the economy, to be able to make our economy a greater economy for everyone to take advantage of. Let me once again say that by virtue of my being here representing the Speaker, and by extension the 360 members of the House of Representatives, I would like to say that we will give you our due support. We will support this initiative, one, because, like I said, it's coming at a very critical period. Two, because it is also intended with the legislative agenda of the House of Representatives and intending by extension to the legislative agenda of the National Assembly. Part of our legislative agenda, indeed, like we have already pronounced, was to create an enabling environment for business people in Nigeria and outside Nigeria to come and create more jobs for our teeming jobless youth in the country. And I want to believe an initiative like this will help us achieve that objective. I will therefore want to assure you that we will support whatever whatever you are coming up with to the best of our ability by way of creating enabling laws that will help to enhance better performance, not only within the business environment, but by extension to the whole Nigerian economy. I want to assure you that you deserve our support because, like I said, it's in tandem with our legislative agenda. You deserve our support because it's also going to create job opportunities for our youth. You also deserve our support because by what we have in the National Assembly, which is an APC-dominated assembly, an assembly that has the majority members of the APC working in tandem with the executive arm of government, and this initiative is also in line with the policies and programs of Muhammadu Buhari, the President of the Federal Republic of Nigeria. Let me, at the end of my very brief remarks, say that I wish you very fruitful discussions. I wish you very fruitful deliberations, and on behalf of the Speaker of the House of Representatives, Right Honorable Yakubu Dogara, and by extension the 360 members of the House of Representatives, wish you well, and we shall always be by your door to give you all the necessary support to make your dream a reality.
Public towards the review of legislative instruments that may be impeding the Nigerian business and investment climate. This is a further demonstration of the synergy with which the Executive and the National Assembly has shown in working together to improve the Nigerian economy through diversification and private sector development for job creation, enterprise expansion, and opportunity for our people. The Ministry of Industry, Trade and Investment fully aligns itself with every initiative aimed at improving the Nigerian business environment. Indeed, the Ministry is already taking similar administrative initiatives to reposition the country's economy for better productivity, and this starts with fostering better business and investment environment. From starting a business to accessing or paying regulatory fees, realign our institutions and make sure that our legal models fit into the new diversified economy. As we deliberate, we need to look inwards to review the role of our regulators and the regulations they make, how they impact on business and investment opportunities and decisions. Regulators today are increasingly being recognized as having significant quasi-judicial powers. The decisions of regulators and how conflicts arising from them are dealt must occupy our minds. We must think out of the box to find independent alternative conflict resolution mechanisms. For a regulatory system in Nigeria today to make any meaningful impact, policymakers should devise, as part of the regulation structure, an alternative conflict resolution structure that is independent, transparent, speedy, and effective. This will, in no small measure, positive impact on growth and development of our economy. Another innovation would be to introduce the policy of notice and comment procedure, requiring agencies involved in decision-making or rules to publish a notice of the proposed rule in some designated register open to the public. Publication in this register will afford interested entities an opportunity to participate in the proceedings either by written comments or oral interviews. As earlier suggested, regulations will also emanate after negotiations with stakeholders in the relevant industry. This could form part of the democratic structures of the economy aimed at reducing conflicts resulting consequences on the economy. Another innovation would be that an agency can only be made to issue regulations upon reasonable determination of the benefits and costs, which must include risk assessment and analysis. During the publication process, regulatory agencies may extend or reopen the period for open comments at any time. Agencies also reserve the right to grant additional procedural rights to interested parties. Furthermore, there is a need to address the problem of assessment and monitoring of regulations. How are simple disputes like billing irregularities, interruptions, and other simple contract breaches be dealt with in simple but less expensive and timely manner within the framework? How will regulations become more amenable to less rigorous compliance processes without untold business hardships? Imagine the collective consequence of effective regulations and commercial dispute settlement to the entire economic framework. A regulation is said to be judged to pass the test if the sum of its future benefits outweighs the present value terms. It will be good to begin now to put into perspective some of these contingencies in terms of formulating an overarching regulation policy and legal framework with a clear-cut objective to form the benchmark for regulatory reforms. Professor Olson will say, the quality of the institution and regulatory framework in a system has profound outcomes on economic reform. This is most crucial when taking a decision for our social and political environment and the need to adequately put in place needed institutional safeguards as we transit. I would also like to seize this opportunity to commend the Senate for the great research on doing business well. We are also delighted in the ranking of the competitiveness of Consumer Protection Bill as high on the bill to given acceleration levy. Protection of consumer cannot be complete or effective without a law that modifies the conduct of business, prevent cartel, abuse of dominant, possible, and other anti-competitive behavior. The mandate of the Ministry of Industry, Trade and Investment to enable trade will be and continues to be jeopardized without a competitive law. We therefore urge the Senate to ensure the quick passage of the bill.
With regards to interaction between the private sector and the legislative arm of government, whose premise the Nigerian public is yet to fully understand or harness since the advent of democracy 16 years ago. We acknowledge the visionary leadership of this 8th National Assembly and commend its dedication to public engagement with the citizenry and private sector, targeted at making Nigeria a modern and globally competitive nation. It is this dedication that led to the first successful roundtable with the National Assembly on setting a legislative framework for high-performance governance at the 21st Nigerian Economic Summit in October 2015. Subsequently, the National Assembly, in partnership with the Nigerian Economic Summit Group, DFID's Enable, Growth and Empowerment in States, GEMS 3 programs, and the Nigerian Bar Association's section on business law, sustained the engagement, collaboration, and consultation. The National Assembly Business Environment Roundtable is a platform designed to ensure that through research and advocacy, the private sector, legislature, and executive engage to promote relevant and sound public policy that affects Nigerian business environment. As part of the activities leading up to this event, a business environment legislative review was conducted, and the final peer review report was submitted to the National Assembly on 29th of February 2016, which identified institutional, regulatory, legal, and constitutional instruments currently constraining and impeding business activity in Nigeria. The findings and recommendations of the Business Environment Legislative Review report provides a framework for the assessment and improvement of legislations and policies affecting businesses in Nigeria, and will direct deliberations at this first National Assembly Business Environment Roundtable event. The report is an embodiment of the canvassed shift for government to be proactive and strategic with regards to creating a conducive environment for business to thrive sustainably. The imperative for this being that over 37 million micro, small, and medium enterprises exist in Nigeria, contributing approximately 50% of GDP in nominal terms, and account for 84% of all jobs. It is therefore imperative that business environment be urgently addressed in order to mitigate negative impacts associated with the current economic downturn, as well as for the repositioning of Nigeria within the global economy. This is why our legislature has a critical role to play by exercising its powers to make, amend, or repeal the necessary laws that would facilitate the development of small and medium enterprises. Permit me to note that without the legislature giving priority to the business environment, the nation risks losing what little jobs are currently available, as well as risk losing the opportunity of moving significantly on the doing business rankings, or indeed the World Economic Forum competitiveness ranking, as it is common knowledge that our poor infrastructure, rather our poor performance, which is largely as a result of constraints in the business environment. I'm, however, pleased to note with confidence that the 8th National Assembly has demonstrated its commitment to making the business environment right in Nigeria by not only supporting this process effectively, but also hosting this event in the National Assembly complex. To underscore the need to ensure that this inaugural event covers the identified priority legislations thoroughly, there will be 11 breakout sessions to discuss relevant legislations in competition, doing business, infrastructure, taxation, finance and investment, arbitration and dispute resolution, e-business, intellectual property, and above all, constitution review. At the end of these sessions, it is expected that the outcomes shall bring a solutions-based perspective to the legislative, constitutional, and regulatory framework for Nigeria's business environment. Your Excellencies, ladies and gentlemen, this is not a one-off event. It will be a continuous process of engagement and collaboration. On our part in the NESG, we have accepted to host the Secretariat of the National Assembly Business Environment Roundtable. In addition, NESG's 10 policy commissions will domesticate the outcomes of the breakout sessions and ensure that the conversation continues until we get results. In essence, we will do the follow-up and the follow-throughs. We therefore request the National Assembly to encourage distinguished senators and honorable members to join the steering committees of our policy commissions. Even more importantly, Your Excellency, we request that a private sector liaison office be established by the National Assembly and located within the National Assembly complex to not only deepen the successes already achieved in this process, but ensure that we stay the course. The need for that private sector liaison office cannot be overemphasized. Your Excellency, my final comment here today is to emphasize the need for strong will on the part of all stakeholders, particularly the leadership of the 8th National Assembly, to timely execute the recommendations that would be made during the breakout sessions.
There's no disguising the fact that Nigeria faces a challenging time at the moment, particularly on the economy. We had our chief economist in country last week, and he was helping us trying to unravel the complexities of the macroeconomic situation. He described it a little bit like this. He said, the problem for Nigeria is you're suffering the curse of medium oil, by which he meant, if you look at the amount of oil that is produced in Nigeria and you multiply by the current low price of oil, and then you divide that by the vast numbers of people, the population of Nigeria, actually there's only around $200 of oil per capita per year to hand around the country. There's no way, even with a rise in the price of oil, that oil itself will raise Nigeria to anything above a middle-income country. And I know that the aspirations of Nigeria go way beyond that to become a high-level income country. So oil alone can't do it, and this is a reality you're facing at the moment. But of course, the low prices of oil can be looked at another way. They can be looked at as, indeed, the perfect opportunity for Nigeria. The opportunity to diversify the economy, to increase investment, and to make industries, by which I mean everything from agriculture to manufacturing to the services sector, to make those industries more competitive. I often hear the term import substitution as a policy of the Nigerian government to help drive local industry. I think you need to replace the word import substitution by import competitiveness. And it's clearly the role of the private sector to help increase that competitiveness and to help fill the gap that the low revenues in oil are currently creating. So it's the private sector, and it's a fantastic opportunity here now to bring this private sector together with the government, with legislature, to have this debate around these bills that you have before you. Of course, the executive is there to implement policies in order to achieve this, but just to stress, the legislature has a key role in ensuring that the right legal framework is in place, and here is my point, so that there is confidence for the private sector to make investment, both local and international. It's the confidence through your laws, through your bills, that will actually invite the private sector to Nigeria. So, as I understand it, you have a dozen or so bills before you to either debate or to pass. A number of them are all ready to go, I understand. I'll mention three that I think that are particularly appealing to us, and from DFID and Enable, the projects I would like you to take quite seriously and push through. One is the Competition and Consumer Protection Bill, which I know is in good shape and ready to go. The other one is the amendment to the Companies and Allied Matters Act, which really affects the private sector. And then finally, one dear to my heart actually is the draft bill around the National Bank of Nigeria, which was an initiative that was started under the previous government to try and basically find a way of making more finance available to small and medium enterprises, which is critical for small and medium enterprises to grow. So personally, I would love to see that bill go through, partly because DFID helped with all the transaction arrangements to create that company.
Citizens to independently create their own jobs and their success using their own talents. And thirdly, that the private sector is the engine for economic growth in Nigeria and indeed anywhere else. So on behalf of my colleagues in the private sector, the big corporates, the small enterprises, and the body entrepreneurs, I thank profoundly the Senate, President Dr. Bukola Saraki, and the National Assembly for taking a thorough, systematic, and transparent approach to this approach, and for understanding that for best results, the public, particularly the private sector, must participate in the process of identifying and debating laws meant to increase their numbers, productivity, and success. I want to also see this opportunity to thank and commend members of the National Nigeria Economic Survey Group. They've been fighting and pushing for this for a long time. I see the past president also there, FOP, Olusegun Phillips, and I see the president, the CEO here. This convening, to a large extent, is a testament to the fact that they know what should be done, and they've been actually fighting and pushing for us to do the right thing. I also want to thank John Smith International, David, and your other partners for the excellent work done with the micro, small, and medium-scale enterprise survey and report that formed the basis for today's discussions. The Tony Elmelu Foundation has also made a submission based on our finding from the survey of the Tony Elmelu entrepreneurs that we conducted on enabling environment. This hopefully should also support the deliberation that we have. I am a proponent of Afro-capitalism, which advocates for the private sector to acknowledge and embrace its critical role in Africa's development. Through the $100 million Tony Entrepreneurship Program, over the next 10 years, we will seek to identify, nurture, and seed 10,000 African businesses based purely on the merit of their ideas. And tomorrow, 22nd of March, we will announce the second 1,000 who will make up the class of 2016. I can tell you from real data that the thirst and talent for entrepreneurship is highest in Nigeria. So far, with about 500 beneficiaries, Nigerian entrepreneurs represent 50% of the TF entrepreneurship program because they represent 50% of the best ideas submitted for consideration. And we have Accenture that does the screening. So it's not as if, not just the screening, the recommendation for the selectees. So it shows that our people indeed can compete favorably. I can also tell you that the enabling business environment is a real challenge everywhere on the continent. From long registration processes and obstacles, lack of access to finance, weak infrastructure, multiple and very complicated tax liabilities, to visa requirements, we have a million ways to extinguish businesses and partnerships before they even begin. The hard truth is we are a continent that depends on our export commodities and the resilience of our entrepreneurs. And that makes us extremely economically vulnerable. Now that the commodity market has drastically let us down, we need to assure our economic recovery and continued growth by lifting our entrepreneurs up. In particular, we need to empower and enable the job creators and future job creators amongst us, by which I mean the startups and small businesses who can create millions and millions of jobs by simply employing one person. They are our salvation, and they are our elevation as a country, especially at a time like this. In closing, I want to say that what we do in Nigeria will set the example for other African nations, and the National Assembly is off to a great start with this initiative. And I do hope and pray that under the leadership of Dr. Saraki, the 8th National Legislative Assembly session will indeed help us move the needle by moving from talking and ideas generation to actually doing and helping to pass these legislative these bills that can help to significantly unlock the opportunities we have in this country. Just to cast our mind back and think that GSM license, the federal, we have seen the multiplier effect of GSM license in this country. The federal government of Nigeria did not spend a dime. All they did was to sign paper. And that paper they signed at the time they did has created significant economic benefits to us by way of tax payments, by way of employment creation, and by way of other economic activities that have been created. This will happen as we pass many of these bills into law. The Land Use Act, everyone complains that access to finance is a major issue in this country, but we have land banks locked up, demonetized. If we could even just challenge ourselves that this year we'll pass the land or revise and pass a new Land Use Act, that can significantly change the course of our economic trajectory as a country. I thank you again for this initiative to unleash Nigeria's entrepreneurs, and I assure you that the private sector will be your partner in this worthy cause to pass the necessary measures to help assure the survival and success of startups, SMEs, and the large corporate.
200 employers, 200 employees maximum. Now, look at their contribution to our GDP, and they employ 57.74 million Nigerians and represent 84% of the Nigeria workforce.
And that is why this job essentially is focused on this sector of our economy. Now, in terms of infrastructure, a lot has been said, severally. A lot has been said about what it will cost this country to fill the infrastructure gap, but in our view, nothing has been done in terms of that this sector, the laws that are relevant to these sectors are passed. For instance, in the power sector, we have the Powers Act of 1954 that later became the NPA Act. When the BP was commercializing, in 1992, it became Nigeria Post PLC. Subsequently, it became the Nigeria Post Authority Act. Essentially, this bill, as this law, has remained the same since 1954. In the rail sector, we have a Railway Act that was passed in 1955. This law has remained substantially the same as we speak. And so, these are laws that were passed at a time when government was the sole provider of what we call public utilities. It's become clear that government does not have the resources. From this slide, it's expected that 52% of the funds for this sector will come from the private sector. I think that is much more than 52%. It's also clear that in the private sector, there's the expertise that is not available in the public sector. And so there's the need to cooperate and there's the need to reform. For us, reform is imperative. The Privatization and Commercialization Act was passed in 1988. Since 1988, we have been moving from public monopoly to private monopoly in this country. And yet, we don't have any regime on competition. Since 2000, there has been a bill on competition that has been moving between the National Assembly and the Executive. I'm sure it's one of the oldest bills in this House. We think that it is time for that bill to be passed so that we have a proper regime that will control this area of the economy. Now, what is the scope of our assignment? The scope of our assignment had three main scopes. First, for us to review the current and proposed laws that are relevant to the business environment. We have done that. In our review, we identified the gaps and the deficiencies in the laws. We did that. We made recommendations. Your Excellency, distinguished guests, ladies and gentlemen, it gives me great pleasure on behalf of my team to present to this House our recommendations, which will be addressed by this roundtable in conjunction with the National Assembly and the private sector. As has been said, we are of the view that if our recommendations are taken into account by this 8th National Assembly, it will be a major achievement by this assembly. Now, how did we carry out our assignment? In research, you carry out legal research, either is doctrinal or non-doctrinal. But in our approach, we adopted the doctrinal. And we did this by looking at the World Bank indicators. Now, I'm sure everybody here knows that Nigeria is ranked 169 out of 189 economies. But not many of us are bothered to ask, why is our ranking that low? As you see shortly, small countries like Mauritius, like Rwanda, Ghana, they rank very high. In fact, Mauritius is 32 over 189, Ghana is 114 over 189, and Nigeria is 169. Why is Nigeria ranking low? We look at the World Bank report and look at the indicators, which we will discuss very briefly, and see the impact of the indicators on the other laws of this country. In 2013, Sweden and Nigeria Bureau Statistics carried out a survey, and we look at the survey to guide our assignments. Last year, the Ministry of National Planning publish what it refers to as the National Integrated Infrastructure Master Plan. That master plan has to do with infrastructure in this country. We also look at the Vision 2020. And we were guided by the scope of work and objectives of the assignment that you will find in the report. Now, in carrying out the review, we found that the current laws of Nigeria are in 14 volumes, and the laws are about 407. We also look at the bills pending in the National Assembly. And we said, for our work to be appreciated, we'll have a format for the presentation of our review. And our format is to identify the name of the act and look at the long title. Why are we looking at the long title? The long title of the law tells you why that law is being passed and its sure is creating. The same thing with the explanatory memorandum. When we look at these two, the long title and memorandum, we're able to identify laws that are business related and those that are not. What are the institutions created by these laws? We examine them, we identify the gaps, and make recommendations. Now, at the end of the exercise, we rank this review into high, medium, and low. The high, those who rank high, are those who consider very, very urgent that should be addressed by this National Assembly. Now, we talk about doing business report, and I like this quotation from the doing business report in 2016. It says, for policymakers, try to improve their economy's regulatory environment for business. A good place to start is to find out how it compares with the regulatory environment in other economies. Also useful to know how it ranks relative to comparator economies and relative to regional average. You will find in our report that in the case of Nigeria, we use Kenya, India, South Africa, and the UK. I also found regional average. And what the World Bank does is to pick commercial cities in the world. Now, we like to know that in Nigeria, Abuja was not used for this study. They picked commercial cities. So for Nigeria, they identified Lagos State and Kano State as the commercial cities. Now, because they picked states and not Abuja, the federal capital, you know that state laws had a major role to play. So, in looking at why we are doing badly in Nigeria, we must look at the laws of Lagos and Kano states and see how they impact on this sector. Now, it's getting harder to do business in Nigeria. Instead of saying doing business in Lagos and Kano State, as if Lagos and Kano State represents Nigeria as a whole. They are looking at processes, they're looking at regulations, they're looking at practices and procedures, not essentially laws. Now, they are worried about time, the duration, and the procedure. So, we're talking about company formation. They're not looking at whether we have PAMA. No, but how long does it take to register a company? How does the company perform? So, we make a submission at the end of this presentation that for us to improve on our ranking, because state laws have a major role to play, we need the collaboration of states to ensure that we do better than we have done in previous years. Doing business has been on since 2005. In 2012, 2014, 2015, this is based on 189 countries. In fact, in 2015, we did fairly well because we moved from 170 to 169. And what are the indicators? These are the indicators. There are 10 indicators that the World Bank uses in assessing how a country does well. Starting a business, we scored 139 out of 189. Dealing with consumer payment. So this slide shows our score. It is the aggregate of these scores that gave us 169 out of 189. We are saying that this is totally unacceptable because Nigeria should improve. And what we find interesting is we have similar laws as other countries, but the difference is in regulations, processes, time, procedure, and challenges in the system. Now, our first key finding is to say, like I said earlier, is that we need to improve on our regulations. We need to improve on our procedures and practices. Now, some federal laws may impact on this, like CAMA. We will talk about CAMA very shortly, and other tax laws. But the main area to focus on is state laws. Now, we'll talk about the fact that the laws of Lagos and Kano were used. Let's look at a couple of the findings. Starting a business. From the report, it takes 5 days to get a name reserved in Nigeria. And they're talking about Lagos or Kano, not Abuja. 7 days to incorporate and pay stamp duty, and 11 days to register a company. Now, look at the UK. In the UK, in 24 hours, you can register a private company online. But if it's by postal registration, it takes 8 to 10 days. Now, you ask yourself, why does it take 5 days to do a name search in an era of IT? Why can't you go online to do a name search? Why do you need to wait for 5 days? Now, you also find that in preparing the documents of a corporation, there are challenges in Nigeria that are going to do with the law. For instance, in 103 countries, out of the 189, there is no more requirement for minimum share capital. Why do you need a minimum share capital for a small company? I'm aware that the Law Reform Commission even recommended that this should be increased. Our view is we do not need a minimum share capital. At the very worst, we should reduce the minimum share capital. Now, if you look at section 18 of CAMA, it says to start a business, there's a minimum of 2 or more. Now, we know that most private companies, even where they employ 200 people, is one man and a son, one man and a wife, one man and a daughter. And the man calls it my company. He doesn't care that it's incorporated, my company. So what you find is, it's really one person running these businesses. Why do we not say in our purpose that one person can form a micro company? Why do we need 2 people to form a micro company? Because like I said, they see them as their companies, and they are run by one person. CAMA provides that you have annual general meeting. The man will stay in his office and draft all the regulations and file. Now, whatever is done, we know this. But why are we comparing for the big companies? For the public companies, we don't have any problem. Our focus is on those who employ 10 people, 50 people, 20 people. Why do we have provisions that are so enormous for them to cope with? Look at section 54 of CAMA. It says to do business in Nigeria for a foreign company, to do business in Nigeria, it must register as a Nigerian company. We ask, what is the meaning of doing business in an IT era, where you can stay anywhere and do business in Nigeria? We have heard the fact that CAMA was passed in 1990, and so overdue for review. There are several areas, like even file of returns. To file annual return, you need to appoint auditors. How many small companies can appoint auditors? So there are provisions in CAMA clearly that are against small businesses that we need to look at. Getting electricity. When you see this, you think it's power supply they're looking at. They're looking at power supply. They're looking at the procedure for getting connected. Now, this is Lagos State. It takes 44 days to submit an application form to a coal distribution company. It takes 31 days. See, all these days are indicated. They are all from, this is why we score so low. When it takes so long to get, not like I said, it's not the supply, whether we have, no. The procedure for getting electricity. Trading across borders. Trading across borders. Now, although we have laws in this area, the laws are caked. In fact, our score here has to do with compliance and documentation. Our documentation is largely manual. Why can't we automate this area. Enforcing contract. Now, it takes 409 days at a cost of 7% of the claim to enforce a contract. We are saying that the chief judges of the states are empowered to make rules of practice. Why can't they use their powers to provide for commercial courts like you have in Lagos State, small claims court, and pretrial conferences? Now, a lot has been said about ADR. But since 2007, there has been a bill in the National Assembly to update our Arbitration and Conciliation Act. My colleague said will remind me that we have the Arbitration and Conciliation Act of 1988. We say that there's a challenge with that bill. Now, on 11th March 1988, when that act was passed, we are running a military regime where decrees were superior to the Constitution. So from 1988, that law was applicable. And in fact, if you look at section 58 of the law, it provides that it shall apply throughout the federation. It was good law until May 1999. From May 1999, when we had a constitution, you look at the exclusive list, look at the concurrent list, you will not find the words arbitration or conciliation. Which then means that arbitration and conciliation are residual and therefore matters for the state. That is why some people argue that, look, it is only states in Nigeria that can make laws on arbitration and conciliation. Some of us agree up to a point, to the extent that when it comes to interstate transactions or international transactions, it's only the federal government that can make laws of that. So when Chibayo JSAN was at the Regional in 2006, instead of a committee, I was a member of the committee, to review these laws, and we drafted 2 laws. One for the federal government to deal with interstate disputes, international disputes, one for state government to adopt. From 2007 to now, only Lagos State has passed that bill of 2007 to law. This 1914 Act was based on the 1889 Act of England. In England, that was repealed in 1950. There was another version in 79. In fact, in 1996, English passed a new Arbitration Act. Meanwhile, most states, and I'm really ashamed to look at laws of some states, you should see the 1914 arbitration. It was an ordinance in 1914. It is the 1914 ordinance that is used. So we are saying that there's a need, 2007 we start from now, there's a need to look at that law that was passed then, update it, and add it to the laws we passed. Payment of taxes, this one area we have done very badly. From the World Bank study, you find that in Lagos and Kano State, they have up to 18 taxes or mandatory impositions. 18. Now, we ask ourselves, if these taxes are based on income or profit, why not have one tax base? Instead of collecting for PDVF, you are collecting for this, you are collecting for this, you are collecting, and it's a burden on these small and medium enterprises. So there's a need to streamline our tax processes. Now, let's look at the laws with regard as key that, in our view, must be. For us today we are entered into an alliance with the National Assembly. We are saying today we are seated in setting an agenda, and that at the end of their tenure, we will judge them by how far these 15 bills have been passed. I talked about the competition one earlier. The number two National Standard Commission bill. Now, what we are having is, let me go to the polls. I was general counsel in BPE when the reform was done in 2005. At the time we did the concession in BPE then, it was envisaged that the post and post bill will be passed to provide for technical and economic regulation. Now, there was a draft bill in the National Assembly in 2005 that up till now is not passed into law. Meanwhile, we did the reform of the ports without a regulator. I'm aware that the Shippers Council, when I was there, we argued that Shippers Council is not properly equipped to carry out either technical or economic regulation. But the Shippers Council today is the regulator for this sector. We urge this National Assembly to pass the Post and Apples Bill so that we can have a proper regulator for the port sector. Now, I'm glad to talk here about the petroleum industry bill. Again, that is a bill that was involved in known as the BPE from 2004. Now, the challenge I have with that bill is what we'll measure very shortly. Most bills here, there are various versions of them. We ask ourselves, why do we wait till public hearing before we know that there are various versions of a bill? In fact, at the point, at National Assembly, when you ask PIB, say which version? Because there were several versions, but the one I saw last was the one that the former Minister of Petroleum endorsed every page. Now, when you look at that bill, and you look at the NCC Act of 2003 and the Electric Power Sector Reform Act 2005, you wait for this country. Now, we're talking about the concept of independent regulators. Independent regulators. Look at the NCC Act. What is it about regulation? Look at the Electric Power Sector Reform Act that created NEC. For an independent regulator, all you need to do in the bill is to provide for the qualifications of those who are going to be commissioners. Don't list their offices. We achieved this with the NCC bill, NCC Act. We achieved this in the Electric Power Sector Reform Act. But the PIB that I saw last, the powers given to the minister under that bill are enormous. Two, they created two regulators for upstream and downstream. Who are the members of this body? Representative of Minister of Finance, representative of the Minister of Petroleum Resources, PEC. These are those to be regulated. They are those who are members of the body to regulate. I can't understand. I really can't understand. So we need to look at this bill to see who are the regulators. Who are the regulators? I mean, how can NUPEG regulate itself? How can PEC? So these are things I think we should look at. The Independent Warehouse Bill, I know that I'm pressed for time. Why I like this Independent Warehouse Bill is one major challenge of the MSME is access to finance and access to land. In terms of access to finance, the Land Use Act has not been too helpful to them. Because from the time this act was passed in 1978, it became an existing law in the 1979 Constitution. If you see an existing law, there's a challenge. Until we remove that act from the Constitution, we will continue to have problems in terms of access to property in this country. What is also interesting, the governor's consent, the procedure varies from state to state. So if you cannot take that law out of the Constitution, there should be a simplified procedure for obtaining the governor's consent. So what this Independent Warehouse Regulatory Bill has done is, okay, use your warehouse receipt as collateral for loan. So if this bill is passed, you find that the private sector can use their warehouse receipts as collateral for a loan. The Secured Transactions in Movable Assets Bill. Under this bill, there will be a registry, Movable Asset Registry. Here, you can use non-fixed assets as collateral to get a loan. The National Development Bank, at the moment, we have the Bank of Commerce and Industry, we have the Bank of Trade and Commerce, we have the Nigeria Economic Reconstruction Fund. What this bill is to do is to consolidate all these laws to make access easy. Franchising bill, I find this very key for the small enterprises. Now, today, the small enterprises will enter into a transaction with a foreign company that is more powerful. So they give you a template, you sign, and that's it. But under this bill, there's a provision for what should be contained in every franchise, so that the terms are not too onerous on Nigeria. So if this franchising bill is passed, it will assist the small and medium enterprises. I'll talk about Kama. Let me quickly move on. Let me not abuse the privilege that I was given by the chairman. Now, this is our last slide before I round up. What are our key recommendations? We are recommending that at the National Assembly, we should have a federal legislative clearing house. Why are we saying this? we found several laws that have created institutions with overlapping and conflicting mandates. It creates problems. We'll start with the ICRC Act and the Bureau of Public Procurement Act. Now, the Public Procurement Act deals with the procurement of works, goods, and services. The ICRC is concerned with PPP transactions. Then you ask yourself, is a PPP transaction procurement of works, goods, or services? We can say that in terms of engaging transaction advisors, yes, you go through the PPP. But when it comes to pure PPP transaction, when the private sector operator is going to use its resources, why should that go through the Bureau? And we also have a challenge with the Bureau of Public Procurement. Your Excellency, one challenge we found in the course of this job is the oversight function should extend to how laws passed by this National Assembly are being implemented. In July 2007, the Public Procurement Act was passed. Section 1 provides for the establishment of the National Council on Public Procurement. Your Excellency, we are aware that from 2007 till now, there has been no National Council on Public Procurement established. Meanwhile, the Bureau has been operating. They've been issuing thresholds, they've been issuing the certificate of no objection. Now, under whose authority do they issue those thresholds? Every Wednesday, they go to the Federal Executive Council meeting. There's no reference to FEC in that act. And our view is, we do not see why FEC should be approving things that are being done. FEC is an alien to that law. So we think that that council should be set up to validate what the Bureau has been doing. There is also overlapping function between PPE and ICRC. Now, the PPE Act was passed in 1999. ICRC Act was passed in 2005. Now, some of the enterprises listed for either privatization or commercialization are also listed under the ICRC Act for concession. Now, if you are, and what normally happens is, these foreign investors, they engage some of us to advise them on our laws before they invest. Now, if you are asked by an investor, which organ of government regulates PPP? Are you going to say PPE or are you going to say ICRC? But ICRC has cured one major defect in the sense that it provides in Section 1 that from the commencement of this act, any ministry, department, agency engaged in the provision of infrastructure can enter into a concession or grant a concession. So the defect in laws that do not provide PPP are cured by the ICRC Act. But we are saying that because of the overlapping mandate, there's need to reconcile these two laws. Now, I'm glad that the DG of CPC is here. There's also overlapping mandate between the functions of the CPC and other agencies. Consumer protection, you have provision on that in the Electric Power Sector Reform Act. You have that in the NCC Act. You have that in some Act. You have that in NAFDAC Act. So, when it comes to issue of consumer protection, there's always a conflict between the CPC and these other laws that provide. I also found, too, that in the Minister Amendment Act, there's provision for environmental issues, which are handled by NESRA. So we are saying that when you have a body that is trying to carry out one particular assignment, why do you duplicate that in other organs of government? And the tax appeal tribunal is an issue that we consider. Now, before 2007, there was no such tribunal. The tribunal was created under the Federal Inland Revenue Service Act. Since its creation, there have been problems with this mandate. You look at Section 251 of the Constitution that provides that tax matters is within jurisdiction. Christy is telling me, Your Excellency, Christy is telling me that my time is up. We need to save the functions of the TAT by looking at the Constitution. We think that the TAT is a specialized court. It should be allowed to do its work. If it means amending the Constitution, we think that that should be looked into. Now, We also think that there's a need to have a forum for National Assembly and State Assemblies, something in the neighborhood of the Governor's Forum, where all these views can be articulated. For instance, we are saying that there's need for collaboration between National Assembly and State Assembly for Nigeria to score highly in the World Bank ranking. Which forum do we have to carry out that assignment? We think that, and thank God, the National Economic Council is leading now. We also think that, although we agree that the National Assembly is not a member of the Council, that is one other venue where this issue of our ranking can be addressed. So we know that the problem is not essentially federal, the problem has to do with state. We will talk about taxes. Let's quickly round up by looking at the Constitution. Section 44, sub 3, deals with vesting the title to mineral, mines, and petroleum on the federal government. We are saying that while we may concede that petroleum products will live with federal government, mines and minerals should be taken out of the Constitution. Because if you go to states like Taraba, Plateau, Benue, where you have mines, the locals, they survive on this. These are these small investors. There should be a way of formalizing what we are doing instead of saying that they must go through the process. We think that that should be emphasized. We talked about Section 251 earlier. Section 315 question deals with existing law. Here, we are concerned with the Land Use Act and the Arbitration and Concession Act. Newer Act, if you look at the exclusive list, and you look at item 36B and 64, it deals with newer. Now, expressly, that item deals with inland waters between state and international. Lagos State is arguing that that item does not cover waters within states. We think there's need to look at that. Then cooperative, we have a federal cooperative act. If you look at item 34 of the Constitution, you find that the operation of cooperative is within the competence of the state assembly and not the federal government. So there's a need for us to look at that. There's also the issue of lotteries. Is lottery a matter for the federal government or state government? We think there's need to look at that. The contributions of the Nigerian Economic Summit Group.
Basically, that is what I'm charged to do. And we looked at the impact in 4 areas, the economic impact in terms of 4 variables: jobs, incomes, growth, GDP growth, and impact on poverty. So those are the 4 key things. We know that we've grown our economy, but we know that growth is slowing down. We know that even while we were stable, it's shocking in some of the comparisons of Nigeria's social statistics with African countries. Professor Idornigie spoke about doing business, 33 nations ahead of us. But even in terms of social indices, many of these countries, Angola, Ghana, Kenya, and even the sub-Saharan average, are better than the Nigerian average. At the end of the day, Nigeria's most critical challenge is to create jobs. It's tied to social issues, it's tied to political issues, it's tied to economic difficulties. Reforms are mandatory. I think that's the takeaway from all of that. And this process is designed to help the National Assembly achieve those reforms, legislative, regulatory, institutional. Mr. Kenny of DFID mentioned the key issue. The challenge is not just with big businesses. There's a temptation when we gather to focus on the needs of big businesses. The challenge is both for the big businesses and the MSMEs, who, as we have seen, employ the vast majority of people, generate almost half of GDP. I won't waste time on the framework we followed. Essentially what we did was to take all of these laws, particularly the priority ones, and of course, put them into sectors. And so 8 sectors emerged: competition and markets, MSMEs, access to finance, transportation, infrastructure, business and commerce, dispute resolution and contract enforcement, all the issues having to do with land use, conveyancing, and building permits. And then we created a last one, legislation, governance, and regulation. So those sectors were the basis of the analysis, both in terms of feasibility and impact. We've spoken to that, and this was the scope of each of the sectors. The
they will be dealt with in. Now, so I will not go into details of some of the feasibility analysis. I'll just show you the outcomes. In terms of risk rating, these are high impact things. The reasons why those laws have not been enacted from 2000 or 2005 or 2007 or whenever, because there are high risks, there are interests, there are significant issues around agencies and implementation. You would see from this that overall risk rating, if we want to achieve this, you have virtually 6 or so that have very high risks, and you have 1 with moderate to high and 2 or 3 with moderate out of the 8. So this is to reinforce the call for political will in dealing with these issues. This includes some implications and recommendations. Again, I won't dwell with that. I'll summarize that as calling for empowering agencies. For instance, the CPC, it has a consumer protection mandate today. It needs to begin to get empowerment in the competition law area and policy area, even ahead of passage of the bill. The issues in transportation are critical, transport and infrastructure, and the interests are strong. And so political will is very strong, much required in there. And the other thing I would mention is, of course, the need to keep the Nigerian Bar Association section of business law on board through this process to guarantee the public interest and the quality of the work that is being done. Those will be some of the summaries. So I'll just breeze through. I've been told to make sure I do this as quick as I can. We went into this with a hypothesis. We can't reach conclusions. A competition agency, if it existed, would conclude whether sectors are uncompetitive. But we went in with a hypothesis that these 7 sectors are either dominated by a single player, or they're duopolies dominated by 2 people, or they're oligopolies dominated by a few institutions. The evidence, I will show some of that as we go along. The logic behind competition law, the jurisdictions that have implemented competition law did not do so because they don't like big corporations. They did so because they found that large corporations, when they become monopolies or oligopolistic, tend to distort the economy. They make people poor, they charge high prices, they offer not the optimum service because they don't have competition, and they delay the progression of the market in terms of quality. I've relied a lot on an UNCTAD report in this report because it's comprehensive, contains multiple researches on the area, and they say here the objection to monopoly is not only that the monopolist is able to charge excessively and reduce production, but also that monopoly is inefficient. And you have that statistic, research-based, that real prices tend to drop by between 25 to 50% when sectors previously uncompetitive become competitive. You also have many other research reports there. I'll just draw your attention to the one in red. Pro-competition policy developments have an impact of 2.5% on jobs. And there's this argument I've heard that, no, we are still a developing country. We can't afford competition law yet. Well, the World Trade Organization says there are reasons to believe that developing economies are in fact more vulnerable to anti-competitive practices than developed countries. And we know why this should be so. Weaker institutions, relative poverty, often presence of corrupt agencies. So that notion that we can afford not to have competition law is one I will urge all of us, particularly this National Assembly, to discount completely. And I offer reflections on the benefits of competition, even in the Nigerian experience. This happened due to market developments, not necessarily due to legislation. But you remember how we used to do banking. I don't need to remind everybody about that. Or you remember can you imagine if NCC had granted a license to only one telecoms monopoly in 2011? We would not have had per second billing. Remember, and I use this media example because many of the people here are politicians. Imagine if you wanted to contest election against the ruling party when there were only monopolistic news agencies. Perhaps your change may not have happened. Our change may not have happened. So competition has tangible benefits, and we see it across our experience. I just do some case studies, and this is not to indict people. Businessmen's role is to become profitable. So we are supposed to then do our duty to stop the creation of monopolies in this economy. These are still hypotheses. There's a hypothesis for arguing that we have uncompetitive, and because of that consumers are paying more, and the development of our socio-economic reality is impeded by that. The CBN has itself said that 8 banks control, and that there's an oligopoly in bank. And I know people in the consumer protection space who believe that has implications for tariffs and so on. Sugar is generally regarded, and these are essentials. Look at all of these things that we've been talking about. Cement, banking, sugar. Somebody said rice. But we did this study. To be fair, in the analysis, if you compare to our neighboring countries, our tariffs are lower. So I make that public admission. But as somebody who looks at economics, I would not compare Nigeria with Benin in looking at tariffs, because the size of the market is vastly different. So the only African economy we chose to compare with in terms of DSTV tariffs is South Africa, because that's the only comparable country. Whether the units or the large or the family or the premium, the prices in Nigeria, it's a hypothesis. It could be because power goes off in Nigeria. It could be because Nigerian workers earn more, I don't know. But these are hypotheses that the competition agency should investigate. So based on all of the research, I won't take you through details of calculations, but in the end, we chose to be very conservative. So where the research says 25 to 50% drop in prices, we said let's even assume a 10% drop in prices. So we were conservative with many of the assumptions, and in the end, based on Nigerian economic data, real data from the National Bureau of Statistics and from other agencies, we suggest that we can create, just using these 7 sectors, plus an economy-wide discount across the economy for other sectors that we may not be recognized, discounted at 10% of what we use for these sectors. We suggest that you could have 318,000 additional jobs over 5 years in those sectors, yearly job creation of 63,000. Income effect, an average of 148 billion yearly and 741 billion over a 5-year period. And also significant poverty measures, as poverty reduction as well. In terms of MSMEs access to finance, the Professor Idornigie has given us the data. We make some conservative assumptions that if we pass these laws, the warehousing, the NOI, the National Development Bank, and all of that, the collateral against charters, and even perhaps the Land Use Act becoming more friendly to medium-scale businesses, we could achieve a 50% increase in capital available to MSMEs. If we did that, and we use the existing economic relationship between resources and productivity based on current data, and that tells us that if you merely increase the resources available to MSMEs by just 50%, you could create 1.5 million jobs yearly, with income growing by an average of 5% per annum. We also look at the area of infrastructure and transportation. And there's global research. 1% increase in public capital, i.e. infrastructure, will lead to a 0.08% increase in GDP. Investments in infrastructure lead to a multiplier in jobs of 0.5. And of course, we took into account the assumptions in the National Integrated Infrastructure Master Plan, which we discounted in the area of infrastructure by 40%, by 60%, just to make them, just to be very conservative. And what all of these tell us is that for transportation, we took transportation out of the whole sector because many of these bills have to do with transportation, and we say, because these are high-impact job-creating areas, transport and infrastructure, labor-intensive, all of that. We project an average of 87,000 new jobs in the transportation sector over the next 5-year period, income growth averaging 7%, a 2.5% reduction in significant impact on GDP as well. In terms of infrastructure, additional cumulative employment of 15 million through a 5-year period with 80% average growth in per capita income. The whole areas of doing business, we lump 3 of those issues together because they are all tied to the doing business indicators, the 10 of them. And we make a very simple assumption. Suppose Nigeria chose to benchmark these countries, not match Rwanda over a 5-year period, or Zambia over a 3-year period, or Kenya over a 2-year period in terms of doing business. That these countries have better indicators than us. So we make these conservative assumptions that if we just grew by these points from our current level over a 5-year period, what will be the impact in terms of those 4 variables: growth, employment, jobs, and poverty? And what we get is GDP growth, average of 5.15% growth, per capita incomes go up by 2.49%, and we achieve a 2.5% reduction in poverty annually. And all of those calculations are there. We just said, okay, we can't, the analysis will be incomplete if we did not assume a cost to this exercise. So we say, what will this cost? It's difficult to find the cost of passing a bill in the National Assembly. So we make some sensible assumptions and divide the budget, the 2016 budget of the National Assembly, into 4 broad weights based on what we think the national 25% of their budget to each of those activities. By the way, this discussion around costs is a notional discussion. Those costs are sunk anyway. Whether the National Assembly passes these laws or not, those laws will be incurred. Those costs will be paid. And we've paid them for the last 16 years. So we thank Senator Dr. Bukola Saraki and his leadership team for the attempt and the committed attempt we believe it is to give the country value for its money. So we assume that, let's even say that this process consumes 75% of the cost of legislation. And that's 21.56 billion naira. And we net all of these costs against the projected benefits, and we suggest the overall economic benefit to this country of completing this process as equivalent to an average of 6.87% GDP growth, growth in jobs estimated at approximately 7.55 million, an average of 16.42% reduction in poverty, over the projected 5-year period, an average of 3.76 trillion to incomes, which is modest. That's only 4.39% of 2014 income figures. My suggestion, sir, members of the National Assembly, distinguished audience, is that the benefits of these far outweigh the costs, and we would be under optimizing an opportunity if we did not pass these laws. Thank you very much.